5, 4, 3, 2, 1, start. Batch of 8 petitions is being decided by a common judgment as the counsel for the respective parties agree that the issue involved in the present batch of petitions relates to compensation for the same transmission line and can be decided together full stop. The challenge is to the award dated 27 February 2016 passed by the additional district judge Sonipat full stop. The landowners have assailed the judgment and decree on the ground that the same is inadequate while the transmission licenses has assailed the award amount to be high full stop. Briefly summarized, the facts of the present case are that the petitioners number 1 and 2 are owners in possession of 3/5 share out of total land measuring 55 canal 7 marla comprising in Khewat number 7, whereas petitioners number 3 to 6 are the legal representatives of deceased Manik Chand and are owners in possession of agricultural land measuring 98 canal 4 marla comprising in Khewat number 65/60 and Khata number 11 situated in the revenue estate of village Malikpur, Tehsil and district Sonipat full stop stanza. The details of the above mentioned land is duly given in paragraph number 3 of the petition full stop. Both above mentioned chunks of land are situated in the vicinity of the border of national capital and fall within the national capital region full stop. It is thus alleged that the land in question has a great market value owing to its potential and that the said valuation has diminished considerably on account of installation of electric poles and the 500 kilowatt high tension wires full stop. The petitioners claim to have received notices in the year 2010 regarding installation of electric poles and erecting 500 kV high tension wire in the land of the petitioners full stop. It is averred that laying of such transmission line has affected the land measuring 7,000 square yards belonging to the petitioners number 1 and 2, whereas land measuring 7,647 square yards pertaining to petitioners number 3 to 6 was also affected full stop. It has been averred that owing to the immense potential of the said land and the same being situated near the national capital, the market value of the land is approximately rupees 6 crores per acre full stop stanza. The respondents, however, awarded a very meager compensation of rupees 92,000 to petitioners number 1 and 2 and a sum of rupees 88,700 to petitioners number 3 to 6 as compensation towards the crop damage full stop. A legal notice was served by the petitioners upon the respondent authorities and thereafter a petition under section 16(3) of the Indian Telegraph Act 1885 was preferred before the additional district judge Sonipat and compensation to tune of rupees 11,000 per square yard was claimed by the petitioners qua their respective affected areas full stop stanza. Pursuant to the notice issued by the additional district judge, respondent number 1 appeared and filed written statement, thereby raising preliminary objections regarding maintainability, locus standi, cause of action, suppression of material facts, etc. full stop. On merits, it has been asserted that the answering respondent had installed towers only as per the sanctioned route map which was provided by the government full stop. The answering respondent had not acquired any land, rather the land in question is fully usable for agriculture even after installation of the said towers in the fields of the petitioners full stop. It was further asserted that as per the provisions of Indian Telegraph Act 1885, the petitioners are only entitled for compensation for the crops only full stop stanza. It has been submitted that notices were issued to the petitioners regarding installation of the towers of the electricity line and for that purpose the answering respondent distributed the compensation for damages to the crops and an amount of rupees 88,700 has also been accepted by the petitioners. Full stop. It was denied that the answering respondent did not adopt proper procedure and also denied that the market value of the land is rupees 6 crores per acre. Full stop. Denying all other material averments, dismissal of the suit has been prayed for. Full stop. Respondent number 2 filed his separate written statement, thereby raising preliminary objections qua maintainability, cause of action, locus standi, estoppel, affixation of proper court fee, etc. Full stop. On merits, it has been asserted that the line erected by the respondents is very high and during installation no crop was affected in the fields of the petitioners. Rather, the answering respondent has paid the compensation for damages to the crops at the time of installation of the said towers. Full stop. Stanza. It is further asserted that land of the petitioners was not acquired and the wires of line pass at a high distance from the ground, and the same being an agricultural land. Full stop. That there can be no obstruction in harvesting of the crop merely by erecting the electric poles and transmission lines. Full stop. Denying all other material averments, dismissal of the suit had also been prayed for. Full stop. It is not in dispute that the respondents had installed towers and high tension wires on the land of the petitioners and that they have not paid any single paisa towards land covered under the poles of the towers or the diminution of value of such lands except paying some compensation to the crops, etc. at the time of erecting towers and high tension wires. Full stop. Stanza. It is an unfortunate case where the lands of the farmers were utilized by the respondents to erect towers and high tension wires, and the reasonable and fair compensation has not been paid to the poor farmers. Full stop. High tension wires were fixed on the land of the petitioners forever. The value of the lands of the petitioners would be diminished, thereby the right to life, which is guaranteed by Article 21 of the Constitution of India, includes right to livelihood, would be affected since they would be deprived of their livelihood in view of the erection of towers and high tension wires over the lands of the petitioners and without paying any compensation for the land covered under the poles of towers or diminishing value of the lands. Full stop. The sweep of the right to life conferred by Article 21 of the Constitution of India to the petitioners is wide and far-reaching. Full stop. It does not mean merely that life cannot be extinguished or taken away, and an equally important facet of that right to life includes right to livelihood, because no person can live without the means of livelihood. Full stop. Stanza. If the right to livelihood is not treated as a part of constitutional right to life, the easiest way of depriving a person of his right to life would be depriving him of his means of livelihood to the point of abrogation. Full stop. Such deprivation would not only denude the life of its effective content and meaningfulness, but it would make life impossible to live, and yet such deprivation would not have to be in accordance with the procedure established by law if the right to livelihood is not regarded as a part of the right to life. Full stop. Article 39A of the Constitution of India, which is directive principle of state policy, provides that the state shall in particular direct its policy towards securing the citizen, men and women equally have the right to an adequate means of livelihood. Full stop. Article 41 of the Constitution of India, which is another directive principle, provides inter alia that the state shall, within the limits of the economic capacity and development, make an effective provision for securing the right to work in case of unemployment. Full stop.